There was a scorecard on the evidence table, thick cream paper, green border, Dr. Adrian Keller's name at the top. Under that, in plain print, it said tea time, 8:12 a.m., Stone Ridge Invitational. I still think about that card because at 8:12 that same morning, Daniel Ruiz was waiting for an emergency heart procedure at St. Catherine's Heart and Vascular Center, and the doctor listed to come save him was holding a golf club instead. That card is why I am telling you this. Before I go further, I need you to subscribe. Not as a formality, because there was one small piece of evidence in this case, easy to miss if you were not paying close attention, that changed the direction of my ruling. I want to make sure you are here when I get to it. Subscribe now, then I will keep going. The file came across my desk on September 25, 2024 at 3:08 in the afternoon. I remember the time because I had one hearing left that day and was already reaching for my robe when my clerk set the folder down and said, "You should read this tonight." Most cases do not announce themselves. This one did. The cover sheet carried 3 times circled in red ink. 7:12 a.m., 7:41 a.m., 8:12 a.m. Underneath those times was a single line from the charging document. On-call attending failed to report for emergency intervention. By 6 o'clock that evening, I knew I was holding a case about choice. Not error, not confusion. Choice. I first saw Daniel Ruiz on the morning trial began. He was 56. He wore a charcoal jacket that hung a little loose on his frame, like he had lost weight and never bothered to replace it. Before he sat down, he straightened his wife Elena's notepad so it lined up square with the edge of the table. That stayed with me, not because it was large, because it was gentle. Daniel Ruiz had taught middle school band for 29 years. While lawyers argued motions, I watched him tap a quiet rhythm against his knee with 2 fingers, like part of him was still keeping time for children with trumpets and drums. When he finally testified, his voice was slower than it should have been for a man his age, but it was steady. Dr. Adrian Keller came through the side door 10 minutes later with both defense lawyers behind him. He was 48, chief of cardiology at West Haven Medical Center, and he wore the kind of dark blue suit that sits on a person like armor because someone tailored every inch of it. He did not rush. He adjusted one cuff, then the other. He set his phone face down, then turned it face up again when he thought no one important was watching. He did not look at Daniel Ruiz when Daniel entered. He looked at the wall clock, then at the exhibits, then at me. That also stayed with me. What happened on May 18, 2024, I did not witness, but I heard it so many times, from so many angles, that by the end of trial, it lived in my mind with the shape of memory. The first call came at 7:12 a.m. from St. Catherine's Emergency Cardiac Team in Briar Glen. Daniel Ruiz had arrived at 6:54 with severe chest pain, shortness of breath, and signs of a worsening cardiac event. Imaging at 7:06 showed he needed an emergency procedure with the attending cardiologist physically present under hospital protocol. That attending was Dr. Adrian Keller. At 7:14, Dr. Keller answered the page. Nurse Linda Cho told him, "We need you here now. The suite is being prepped." He said, "Start what you can. I'm tied up for a bit." At 7:23, after a second page and a direct message from a resident, he said, "Call Mendel if you're going to panic." Dr. Samuel Mendel was not on call. He was 40 miles away at his daughter's college orientation. At 7:41, the gate camera at Stone Ridge Golf Club recorded Dr. Keller's black Mercedes GLS entering the property. The club was 24.6 miles from St. Catherine's. At 7:52, he signed in. At 8:03, he was seen near the practice green. At 8:12, his group teed off on hole 1. At 8:17, Daniel Ruiz lost consciousness in the hospital. At 8:31, another cardiologist, Dr. Priya Nandakumar, was reached at home. She was not on duty. She threw on clothes, drove in, and entered the hospital at 8:46 in running shoes under a borrowed surgical gown. The procedure began at 8:58. Daniel Ruiz lived. That matters. He lived. But the delay left permanent damage to his heart, months of rehab, heavy medical costs, and the end of the teaching career he had planned to finish on his own terms. At 9:11, when the hospital administrator finally reached Dr. Keller, he said, "I made a judgment call. I am going to tell you something that did not come out until the 3rd day of testimony, something that made me ask a witness to repeat herself because I wanted the words exactly right. If you are not subscribed yet, do it now, because that moment is coming, and I do not want you to miss it. Before the jury ever entered, the case was already teaching me how much of the law depends on quiet paperwork. The prosecution moved to admit pager logs, gate records, the Stone Ridge sign-in sheet, and a printed scorecard. The defense tried to keep the golf evidence out. They argued that wealth would poison the room. They were partly right. A jury cannot punish a man for belonging to the wrong club or driving the wrong car. So I excluded photographs of his house, sponsor gifts, and lifestyle details that did not help prove the charge. But I admitted the records that fixed him in time and place. A business record does not care about pride or shame, it only says what happened and when. That is a detail many people do not know. Trials are not built out of speeches first. They are built out of foundations. Before a jury can hear a fact, someone has to show me why the law lets it in. The public sees the drama. I see the hinges. On the first morning of trial, I watched everyone enter from the bench the way I always do. Daniel Ruiz came in with Elena on his left side, though I could already tell she was the one ready to catch him if he wavered. He held the rail with one hand. He nodded once to the bailiff and sat. Elena Ruiz carried a canvas bag with pill bottles inside. I knew because I heard the soft clink when she set it down at her feet. She never looked at Dr. Keller on the way to the table, not once. Dr. Keller entered beside counsel with his shoulders set wide. He touched the knot of his tie in the dark monitor screen before it lit up. As he walked past the prosecution table, he looked at the exhibits before he looked at the people. Then the evidence began. The first wave was plain and hard. The emergency physician described Daniel Ruiz's condition on arrival. The imaging tech fixed the scan at 7:06 a.m. Linda Cho took the jury through the protocol binder page by page and showed them the rule that the attending cardiologist on call must appear in person for a case like this. The prosecutor asked what happened if that attending did not arrive. Linda Cho said, "We wait or we break protocol, and if we break protocol, someone owns that decision." I wrote that down. The pager logs followed, blue and white entries with timestamps so clean they seemed almost rude. First page, return call. Second page, escalation message, the resident's text. Then the gate camera still from Stone Ridge at 7:41. When that image came up, I did not look at the screen first. I looked at Daniel Ruiz. He lowered his head and pressed his thumb against his wedding ring until the skin went pale. The second wave made the case harder, as real cases usually are. The defense called colleagues who said Dr. Keller had been overworked, that the hospital leaned on him too often, that emergency backup procedures existed for a reason, and that medicine can turn on judgment under pressure. I listened closely because fairness means listening hardest when the room is already leaning one way. They also brought in an expert who said Daniel Ruiz's condition was serious from the start and that no one could promise a different outcome if the procedure had begun earlier. That testimony mattered. It deserved weight, but it did not erase the drive to the golf course. Then came Teresa Bell, the tournament coordinator from Stone Ridge. She was not dramatic. She was organized. She brought a folder, answered carefully, and identified the registration sheet, the pairings list, and the welcome bag receipt. Then the prosecutor asked if anything else happened near tea time that morning. She said, "Yes, he took a call." I want to stop here for a moment, because what I'm about to tell you is the part of this case I sat with the longest before I felt ready to speak about it in public. Subscribe before we go further, then take a breath. Because this next part matters. I asked Teresa Bell to repeat herself. She said that at 8:09 a.m., 3 minutes before tea time, Dr. Keller stepped away from the registration tent and answered his phone. She did not hear the start of the call. She heard the end because she was close enough to hand another guest a pen. She said he looked irritated and said, "I said get someone else. I'm already on the first hole." That was the moment the room changed. The prosecution followed that with cell tower records placing his phone at Stone Ridge during the full period of the delay. Then they offered a short video from a sponsor's social media post. It was not made for court. It was made for donors. In it, people laughed near the first tee, and for less than 2 seconds, Dr. Keller appeared in a white quarter zip with a driver in one hand and his phone at his ear. 2 seconds. That was all. The defense objected. I sent the jury out. We argued foundation. Then I let the clip in for a narrow purpose. Not to mock him, not to inflame the room, only to place him where the state said he was when the hospital said he was needed elsewhere. When the jury watched it, Elena Ruiz closed her eyes once and opened them again. Dr. Keller removed his glasses and cleaned lenses that did not need cleaning. Then Daniel Ruiz testified. He said that before he lost consciousness, he heard one nurse ask if the doctor was coming and another say they were still trying. He said, "I kept thinking there had to be a reason. You do not tell a man help is coming unless it is." That sentence never left me. He talked about waking later with weakness in his left side, constant fatigue, and a body that no longer answered him the same way. He said the first time he tried to conduct the school band after rehab, he had to sit down after 6 minutes because his chest felt heavy and his hand would not keep time. When the defense asked if he knew for certain the doctor's earlier arrival would have changed everything, Daniel Ruiz said, "No, I know he was supposed to come." That answer did not sound large in the room, but I have never forgotten it. The defense case rested on a line I have heard before in different forms. They said this was not cruelty. They said it was misjudgment inside a strained system. They said St. Catherine's had weak coverage planning. They said others could have acted faster. They said criminal law should not punish a doctor for a bad call in a bad hour. I considered every bit of that. Courts should. Systems fail people every day. But this case had one fact the defense could not bend around. Dr. Keller was not trapped in another operating room. He was not passed out from exhaustion in a call room. He was not driving toward the hospital through closed roads. He was at a golf tournament. When Dr. Keller testified, he spoke in the calm voice of a man long used to being taken seriously. He said, "I was balancing multiple obligations." I wrote it down. Later, he said more softly, "I thought I still had a little time." I wrote that down too. Then, when the prosecutor asked whether part of his choice had been about not wanting to leave a public event in front of donors and colleagues, he paused and said, "I have patients, a family, and a reputation. One mistake should not erase a lifetime." I wrote that down exactly as he said it. I have told this story before, to colleagues, to my family once. And every time I reach this part, I go quiet for a second. Subscribe to this channel if you want to hear what comes after the quiet. I promise it is worth it. There was a memory from my own life that came back to me during Elena Ruiz's testimony. I was 12 years old in a hospital hallway with my mother while my grandfather waited for surgery. A vending machine hummed. My mother held a paper cup so tightly the middle of it folded inward. She kept looking at the clock over the nurse's station, then at the swinging doors, then back at the clock, as if looking hard enough could make a doctor arrive faster. I had not thought about that memory in years. Then Elena Ruiz sat down in my courtroom and said, "I watched that hallway door like it was a person." No one wrote that line for her. It came from somewhere real. By the time closings ended, I had made my decision. I had made most of it days earlier, if I am honest. But truth spoken aloud does not land the same way truth carried in private notes does. The morning of the verdict, the courtroom filled early. Daniel Ruiz sat with both feet planted wide, as if he were bracing for a hard stop. Elena kept one hand over his forearm. Dr. Keller sat straight-backed with an untouched legal pad in front of him. I read the counts one by one. Felony patient neglect causing serious bodily injury. Guilty, falsification of medical records. Guilty, reckless endangerment. Guilty. I did not hurry the words. The first reaction I noticed was not Dr. Keller. It was Marisol Ruiz, Daniel's daughter, in the second row. She covered her mouth with both hands and bent forward until her forehead touched the bench in front of her. No sound at first, just that movement. Then Elena Ruiz let out a breath that sounded like something old leaving the body. Dr. Keller closed his eyes once, then opened them and looked straight ahead. The verdict was not the hardest part of this case for me. The sentencing was, because sentencing is where I had to decide not just what was legal, but what was right. Subscribe so you do not miss what I decided. I am getting to it now. 3 weeks later, I came back into that courtroom with a sentencing order written in longhand first, because I wanted to feel every line before it became law. I had read letters from former patients who praised Dr. Keller. I had read statements from nurses who no longer trusted him. I had read bills, rehab records, and a home estimate for a stair lift. Sentencing is where a judge feels the edge of what a court can do. I cannot give Daniel Ruiz back the morning his life turned. I cannot return the strength in his hand by speaking into a microphone. But I can draw a line between privilege and duty and make the line count. So I looked at Dr. Keller and said, I am ordering you to serve 180 days in county custody, to be completed through weekend confinement over the next 12 months, followed by 5 years of supervised probation. I am doing that because this was not a charting error or a missed email. You were told a life was waiting on you and you chose to be elsewhere. I said, I am ordering you to pay a fine of $250,000 to the St. Catherine Patient Safety and Family Lodging Fund. I am ordering that because when hospitals fail, families pay in nights, miles, meals, and fear. That burden should not fall only on them. I said, I am also ordering that you be barred from emergency on-call medical service for 5 years, unless the medical board restores that authority in writing. That means no emergency pager duty, no backup emergency listing, no representation that you are available for urgent cardiac response. I am ordering that because a call sheet is a promise. I said, I am ordering 1,000 hours of community service at Mercy House Cardiac Recovery Center and the West Haven School of Medicine Ethics Program. Those hours will include patient transport, family intake, rehab support, and speaking to first-year residents about duty, delay, and the cost of treating urgency like an inconvenience. I am ordering that because this harm should teach someone besides the people who suffered it. Then I stopped and looked down at my notes. I said, and there is one more thing. I said, within 30 days you will stand before the St. Catherine Hospital Board, emergency staff, and any patient families who choose to attend, and you will read a written statement in your own voice. That statement will include the timeline of May 18, 2024, the choices you made, and the harm that followed. It will also be published in the Briar Glen Register and on the hospital website for 60 days. I am ordering that because public trust was used in public, and it must be answered for in public. Then I finished. I said, you will also fund Daniel Ruiz's cardiac rehabilitation, his medications related to this injury, the stair lift recommended for his home, and a mobility-adapted vehicle for 3 years up to $190,000 in documented cost. I am ordering that because the man who paid for your absence should not keep paying for it month after month. After that, I spoke to him directly. I said, what you did was not only fail to arrive. What you did was leave people in that hospital spending precious minutes pretending your words still meant something. You cost Daniel Ruiz heart function, income, strength, and the plain trust a patient is supposed to be able to place in a doctor's promise. I said, your family will live beside the consequences of this sentence, but they did not make the choice you made on that first hole. I said, privilege in a profession is not a reward for being admired. It is the burden of being counted on. Then I gave him the last sentence exactly as I had written it the night before. I said, I believe you knew what was required of you, and I believe you chose yourself. Thank you for staying with this. I mean that. I know this is a long story. I know it is not easy. Subscribe if you have not yet. You already know why you are still here. When court ended, the room emptied in pieces. One lawyer set his pen down and stared at nothing for a full 5 seconds. The court reporter rolled her shoulders back from the machine. Dr. Keller's wife reached for his sleeve and missed it the first time because her hand was shaking. What I remember most is Daniel Ruiz. He looked at Elena first, said something I could not hear. She nodded. Then Marisol came around the bench row, crouched beside him, and tied the lace on his left shoe because it had come loose. That is what I saw from where I sat. A daughter fixing one small thing for her father after a long day in court. The appeal went to the Court of Appeals for the 3rd District. Oral argument was heard 8 months later. 14 months after sentencing, the panel affirmed the conviction and sentence in all material respects. The opinion said the record showed a conscious disregard of an immediate medical duty after repeated notice of urgent need. I was not surprised, but I was relieved. What came later belongs less to the court and more to the long life that follows a judgment. Still, I learned some of it. On August 14, 2025, I attended part of a patient safety forum at Mercy House Cardiac Recovery Center. Daniel Ruiz was there. So was Dr. Keller, seated in the second row with a yellow legal pad, still serving hours. Daniel walked to the lectern without a cane, slowly, but without a cane. That mattered because he had used one when I first saw him. He adjusted the microphone himself and said, "I drove myself here today." No one rushed to clap. They listened first. Dr. Keller stood when Daniel passed by after the program. Daniel nodded once and kept walking. I do not know if that was forgiveness, distance, or simply tired grace. I never asked. The question this case left me with is not whether I ruled correctly. I believe I did. The question is how many small excuses a person gives themselves before they can step over someone else's emergency and still call themselves decent. I do not mean doctors only. I mean anyone trusted with time, access, money, authority, or the right to say, "I'm coming." Good work done over many years does not erase one selfish choice, but one selfish choice does not always begin in cruelty. Sometimes it begins in habit, in being excused too often, in being told again and again that your schedule matters more than other people's fear. I have seen that pattern in other courtrooms wearing different clothes. If you are someone who has lived on the side Daniel Ruiz lived on, if you have waited in pain while the person with the power to help treated your need like something that could slide a little farther down the list, then you know the look I saw on his face in this courtroom. It is not only fear, it is the moment a person understands that the one they were told to trust may not feel the weight of their waiting the way they feel it themselves. And if you are someone closer to Dr. Keller than to Daniel Ruiz, if you are the one people organize around, then here is the question I wanted to ask him but could not ask from the bench. What have you taught yourself not to feel when other people wait on your word? If that question stays with you, do one thing. The next time you know you cannot truly be the person they are counting on, say it early. Step aside before your status makes someone else pay for your delay. There are other cases I want to talk about. This is not the only one that stayed with me. Subscribe and you will hear them when I am ready to tell them. I keep coming back to that scorecard. Thick cream paper, green border, tea time at 8:12 a.m. It looked ordinary. That is part of what stays with me. Harm often begins beside ordinary things. That is why I told you this story. If you want to hear the others, and there are others, subscribe. That is all I am asking. Subscribe and stay. And if you write in the comments, write where people who still care about the difference between being important and being responsible can find one another.